Good morning, everybody. I think we're going to get started on the next panel. I'm Dan Sharfstein. I'm a professor of law, and I'm director of the George Barrett Social Justice Program. And it gives me great pleasure to welcome you to the Law School panel. We wanted to honor and explore Dr. King's legacy by focusing on what he saw as a key set of issues in the struggle for justice in the United States, fairness and dignity for working people. We have a wonderful group of panelists and a relatively short time, so I'm going to be very brief in my introductions. Suffice to say, we could spend the entire time just introducing these panelists. I'm just very excited that they're here. So I'll introduce them in alphabetical order. We have at the very end Samir Ashar, who is a professor of law and vice dean for experiential education at UCLA. He recently started there after many years at UC Irvine School of Law, where he was the founder and co-director of the Immigrant Rights Clinic. Next, second in is Rocio Avila, who's the National Domestic Worker Alliance's state policy director and focuses on policy and legal advocacy on behalf of domestic workers through state legislative and municipal campaigns. Next, on the end here, is Llezie Green Coleman, who's an associate professor of law at American University's Washington College of Law, currently co-directs the Civil Advocacy Clinic, and specializes in employment law, the intersection of workplace exploitation and immigration, and has done important research on the intersection of race and wage theft in low-wage worker communities. Then we have Jennifer J.J. Rosenbaum. J.J. is currently with the Global Labor Justice Project and is a lecturer at Harvard Law School. And then finally, our moderator today is Alex Herder, who is a longtime, legendary clinical law professor here at Vanderbilt, I'm just delighted that he's here to moderate. He thinks he's emeritus, but I have other plans for him. So, Alex.
Thank you, Dan. I am grateful I was able to be here for the Divinity School panel this morning. I wish we could hear that kind of truth spoken from every podium and every pulpit in the land. Okay, I'm Alex Herder. I think the reason Dan asked me to moderate this panel is because I was in Memphis as a volunteer for Dr. King's lawyer, Walter Bailey, when Dr. King was shot. I was one of the first people arrested that night and held in the Memphis jail. Just briefly about that, I was a first-year law student at Duke Law School in April 1968 when DeArmey Bailey, many of you may know him as a judge in Memphis, he was director of the Law Student Civil Rights Research Council in New York City, and he was looking for 10 law students to help his brother Walter Bailey, who was Dr. King's lawyer in Memphis. 4 of us from Duke volunteered. We flew into Memphis on the same plane with Dr. King. We met him in the airport, and he thanked us for coming. On the day Dr. King was killed, we had spent the day interviewing workers who were beaten by the police in the march a week before. That evening, we had dinner at a restaurant near the Lorraine Motel. At 6:15, I left the restaurant with another law student from the University of Mississippi, and we walked past the Lorraine Motel. Someone was shouting, "Dr. King has been shot." We stood there in shock. Suddenly, police cars surrounded us, they handcuffed us and took us to jail. Around midnight, Walter Bailey made a courageous trip to the Memphis jail and got us out. We left the next morning. the police told Walter Bailey we were not suspects. The police had asked us, what were we doing in town? We were investigating their treatment of the marchers, but tried to make that kind of diplomatic. We didn't know what was going to happen to us while they were holding us, and we were grateful to be released. I have been involved in civil rights, labor, and anti-war movements for the rest of my life. These three movements came together, civil rights, labor, and anti-war movements. They came together in Dr. King's work, and particularly in the Memphis campaign. Dr. King, the leader of the civil rights movement, had stirred controversy the year before by denouncing the Vietnam War. Some people had turned against him because of his stand on the war, but the black workers in Memphis and their union AFSCME turned to him for leadership. Our panel today represents these same three themes: civil rights, labor rights, and solidarity with workers from all over the world. Our goal in this panel is to have a conversation about the work they are doing and the challenges they are facing. I'd like to start off with a quick reflection on the work Martin Luther King was doing then, with a question for the panelists, which would be, what are the parallels you see between what's happening today and the environment for labor and people and workers that Martin Luther King was working to change at that time? This will be a conversation, so people can pick it up and take turns.
I'm going to start us out, but I hope that all of you join in. So first of all, I just wanted to thank Professor Herder, Professor Sharfstein, Dean Guthrie, Sonia Hubbard, I believe, who helped bring us all here to this panel, to this conference, and to speak on this panel. I also want to say that I feel a little bit like I'm in the opening band, but I'm going after the headliner because the thing that I was thinking, listening to that first panel, was just like spitting fire. Folks were speaking. A lot of people say truth to power, but that's what I heard on that panel. And we'll do our best to try to not live up to that, but to complement it in the ways that we can. The first thing I'll say is that law is constitutive in the sense that the kinds of white supremacy that was discussed on the first panel is actually constituted by law, right? Law entrenches white supremacy. Now, some freedom fighters have tried to use law to take apart white supremacy, right? Including Dr. King and others over time. But the first thing, to me, that I think we need to grapple with, if we're going to talk about workers' rights, both Native American workers as well as immigrant workers in low-wage sectors, is we need to grapple with when law is working to denigrate, make disposable the bodies of black and brown people in workplaces. And that's done in lots of different ways through law, right? Most primarily, you have to say criminalization. Criminalization operates again, across the color line. It operates both, obviously, in the ways that were talked about in the first panel in terms of the way in which police treat African Americans, but also criminalization infects the immigration legal system, as everyone probably knows by now. That is, criminalization is the carrier. It's the way in which the government, the state, is able to sort of, again, make disposable the bodies of Latino, Asian, other immigrant, African, Caribbean immigrant workers in the United States, to other those people and to give them less power in the workplace, right? So if we're going to talk about workers' rights and labor rights, then we need to grapple with the implications of criminalization, the use of law to divide people and to denigrate them, and to take away their power to organize, right? So, Professor Herder, when you say, you know, what's different, you know, one thing is institutionally unions are not, don't have the kind of strength that they had at that time, for better and for worse, in the sense we see even from the Memphis struggle that there were some unions, and from Dr. King's, you know, struggle, that there were some unions that were allied with him, and there were others that were opposed to him and actually challenged him and the movement more generally for civil rights. But there were progressive unions that supported the struggle, that provided important funding for that struggle. And the fact is, we just don't have that kind of institutional union presence because of a 50-year war on unions, effectively. Some philanthropic foundations primarily have kind of tried to fill the void. It's a clearer field that allows for green shoots of really exciting creative organizing that are happening at the grassroots, like Fight for 15 and other kinds of organizing efforts. But also, I think something like Fight for 15 at least is partly funded through sort of the remaining union strength that exists. So the lack of kind of an institutional infrastructure, or the weakening of that institutional infrastructure, creates openings. But I would say it's a very challenging context because of that absence and that weakening in the last 50 years, and because of the strength of the state in the way in which it's sort of criminalizing workers.
I think I'm going to jump in because I think it's a good connection to the work I do and the National Domestic Workers Alliance. And for those of you who are not familiar, NDWA is a national organization that advocates on behalf of domestic workers. And these are workers who work in the private homes caring for people and people's livelihoods. Many of them are nannies, home care workers, house cleaners. And the NDWA was founded in 2007 as a result of many years of organizing in low-income immigrant communities and communities of color, both in the East Coast in New York and in California. We're up to 60 affiliates across the country. And the reason I wanted to jump in response to Samir is because I think NDWA's model of organizing and doing legal advocacy provides an alternative. While we understand very clearly that the legal system is embedded, is white supremacy, I think because domestic workers have always been in the margins, they were excluded from the New Deal in 1938. They were not granted the opportunity to organize. The same was for farm workers in the Southwest. And to this day, until recently, in 2015, to be very precise, we were able to extend overtime to home care workers, 2015. So what we've done in the midst of that has been to invest in our workers by providing tools to develop their leadership so that they engage in both legislative fights that at the helm are to change the law, a law that unfortunately sometimes is unfair and doesn't respect the dignity of their work. But at the same time, we've been moving in the last 5 years to create alternative legal methods that allow us to do more bargaining and allow us to actually be at the helm setting the standards and wages. So when I think about the legacy of MLK, I think he would be proud of the work of NDWA and domestic workers because they have not sat around and limited their opportunities based on the current legal system, which doesn't address their working conditions anyway. And we're doing it by virtue of forming wage standard boards. For example, we passed a legislation in Seattle this past summer that is the first in the country that's going to bring workers, employers, and government to actually provide avenue for workers to have portable benefits. I don't know if you all have heard of the system portable benefits. Domestic workers at this point don't have access to basic safety nets, which is the same issue that many workers faced in the 1960s. Domestic workers, unfortunately, are still getting paid at least a little above minimum wage, but they're not getting safety net protections of health care, sick time, workers' compensation. So I think that in the struggle for civil rights, because domestic workers are primarily immigrants and women of color, we don't have the luxury of not addressing these other issues of institutional racism and the issues around immigration, because they've always been intertwined given the history of how domestic workers have been treated in this country.
So I think I'm going to jump in here in part because I want to, in the same ways, kind of like acknowledging and respecting it, and myself having come from a space of representing exploited workers and often having represented immigrant exploited workers, that one of the things that I found over time in many ways that I think is somewhat different from what was happening in the 60s is an absence of Black voices in that space. And so one of the things that I discovered over time, and I practice law in Washington, D.C., I direct a clinical program where we handle a lot of wage and hour cases for workers, and most of our cases are referred. And I, over time, kind of noticed that all of our referrals, or nearly all of our referrals, were immigrant Latino workers. And that was fine. It wasn't really a problem, but I'm in Washington, D.C. And so I was kind of thinking, where are the Black workers? What's happening? Because what we know from the studies is that wage theft occurs across all populations. So I know that there's a working class community in DC, but I'm never seeing any referrals. And when I started kind of asking organizations what they're seeing, in the field and in the communities, they were saying, well, yeah, Black workers are never complaining of wage theft, which made very little sense to me based on, again, what we know. And in fact, I went to a conference in Chicago, and there was a gentleman there who worked for a worker center in Chicago on the south side of Chicago. And I asked, do you also serve African-American low-wage workers? And he said, well, there was that one. I mean, that was literally the way that he responded to it. And indeed, and in some ways, I wish I'd taken better notes of that interaction, because in the language he was using was almost as though exploited worker meant immigrant, and this Black woman who'd come into their office who they couldn't serve because they had no materials in English, wasn't an exploited worker, that somehow she was different. And so one of the things that I've been looking at is how we have, in terms of our conversation about low-wage workers and exploited workers, we have created a narrative that is sometimes very narrow. And in many ways, I say this in some ways trying to be cautious, because I'm also not trying to set up some binary or some sense of it's, Black workers versus immigrant workers versus, or Black workers versus exploited Latino workers, but really more concerned that in some ways our narrative we have become very comfortable with the narrative of vulnerable immigrant worker exploitation. And we're comfortable with having those conversations, and people are comfortable providing funding to organizations that are working in that space. But if you start to talk about it as an issue of racial justice, and I actually think that it's an issue of racial justice both for Latino workers and for Black workers, that we're much less comfortable with that conversation. We're much less comfortable with providing funding for Black worker centers. It's one of the complaints that we hear in the communities, is that it's very difficult to obtain funding because racial justice is not something that's being funded in the same way. And I think that is in many ways tied to that criminalization idea that Samir mentioned, which is this concept that poor Black workers are criminals and are clearly doing something wrong, and that as a result, that's kind of why they find themselves in these exploited circumstances. So there's this very kind of interesting absence of certain workers' voices, I feel like right now, in the low-wage worker movement and in the communities and definitely in the scholarship and the literature. When I started thinking about writing articles, I realized that almost no one was writing about the exploitation of African-American low-wage workers. So I've been trying to fill some of that space and thinking about what are the dynamics that make that experience somewhat different, related to, but a little bit different from exploited Latino workers. But I think that that's a very significant difference in terms of the dialogue that we're having. In some ways is centering a different group. And I think we have to fight to make sure that we have an expansive dialogue about what's happening to low-wage workers of all races and origins and ethnicities in this country.
So I want wanted to echo the thanks that Samir gave to and add also Spring Miller to the list of folks to thank, who's here really trying to work with students day to day to figure out how they can all do the kind of work that we're talking about on all of the panels. And also to say I was deeply moved by the first panel, and I think it's very appropriate that the day starts with theologians and organizers and visionaries, and that we, a lot of what we're talking about is tactical, and how to really support those movement visionaries. And one thing I think that's the same from what Professor Herder mentioned is that the very creative, innovative defense of organizers and theologians at the front lines, whether it's coming as a law student to support Dr. King's lawyers, or supporting hunger strikes and immigration detention, or all of the many ways that folks right now being in the streets with Law for Black Lives are doing this work. It does require figuring out who needs to be defended in what work, and then coming up with creative legal strategies to do that. And I think at this moment in time, we need more of that, and we need more that is very intersectional around racial justice, economic justice, immigrant rights, in the most creative way possible. I wanted to bring a little bit of a global dimension to the discussion, because I think one thing that is different than the 60s is the globalization of the economy. It's very much in the interests of the folks with more money to expand labor markets globally, just as they have tried to expand them throughout the South and throughout the United States, and now more broadly to move production of goods to places where labor costs are lower, where regulatory costs to protect communities from unsafe and unhealthy conditions are low, and increasingly then also to move people to those places, so that it's not even the people in those places that get the not great jobs. And so that's the work of the Global Labor Justice Project, which is a new project supported by Jobs with Justice and many worker centers around the country, is looking at very experimental organizing between grassroots, community groups, worker centers, migrant groups in the United States and in other places, to really find those points of leverage on global supply chains, on global financial networks, and across migration corridors, connect grassroots organizing into places, and think about what legal and policy and human rights levers can actually move to push on these incredible global networks of power. Because I think ultimately we see the financial sector moving money, we see the jobs moving, we see Steve Bannon and the right wing moving globally, and we as the people's movement want to move globally also, and we want to see the opportunity of that to strengthen our movements, to learn from other places, and to create the really bottom-up pushback that I think has the possibility to transform globalization in a way that's different from either what might be seen as the people that like globalization because they're going to get rich from it, or the folks that are, really wanting to close borders and act as if, we can save some small section of jobs in the United States at the expense of the rest of the world.
Now, you can go on, or I have, but let me just bring up another question here, because all of you work in worker-led movements. You're lawyers for dynamic organizations that have a mind of their own, and and the organizations you work for devise strategies and look for what to do. You're not in the lawyer-driven strategies that sometimes you see. Any problems with that? How do you deal with that? Is it different from other types of lawyering you've experienced? And how do you deal with being in second chair and listening to your clients?
So I'm going to respond in part because I actually don't work in the midst, directly in the midst of a worker-led movement. But I'm a clinical law professor, so what I'm teaching my students is client-centered lawyering, which means that all lawyering should be worker-led. So in some ways, even though I'm like my clients at this point at least aren't typically organizations, we're still being led by the workers who come to our office and indicate that they're not being paid, and we're centering them in the conversation about how we can actually best serve their needs. So I want to challenge, I mean, I think that it is a critically important critique of much lawyering that has often centered the lawyer in the middle of the conversation, but I actually think that you can be a worker-led lawyer even if you're not working for a worker-led organization. And that is literally, it is also a mindset about how we think about the work that we do as lawyers and who we think the client is and how we think the client should be engaged in the process of any decision-making and problem-solving for the problems that they bring to our offices.
Yeah, I can add. I've done both. I've represented also workers on wage claims and did direct representation for 9 years before I went to the Alliance. And I felt that experience was really what really shaped me to be a community attorney by virtue of having contact with workers because it allowed me to see the patterns of what was going on in the community, to be able to address how to resolve issues of wage discrimination for all workers. And then now, as in my role at the Alliance, all of our campaigns are led by our affiliates. We have convenings, and the workers themselves identify what their priorities are. As an attorney, I simply provide the skills of synthesizing, doing the research, and giving them recommendations, but it's directly based on the experiences that they are facing on a daily basis. Most certainly, given my experience representing them and understanding how difficult it is to bring a wage claim and to produce wage calculations and to settle claims, informs and shapes how I then submit or produce some recommendation. So it's this combined experience that I think makes a solid or a different kind of lawyer. If I was just having worked directly with workers and not have the experience to also see the other side of how the implementation affects people's lives, I think it wouldn't make me as strong of an advocate.
I'd like to answer that by going back to history. I mean, I think most folks are familiar with splits within the civil rights movement between, the LDF and the Southern Christian Leadership Conference and SNCC on the one hand, and then SNCC and other orgs on the other hand, more grassroots sort of generational splits within the movement. And what less people know, although Tomiko Brown-Nagin at Harvard has written an amazing book tracing what the lawyers were doing in that context. That is, those movement organizations were choosing lawyers to work with, and the elite lawyers were working on the impact strategies with the established organizations, with the older generation within the movement. But there were National Lawyers Guild lawyers, most prominently, one of my new heroes that I've discovered through Brown-Nagin's work is a man named Len Holt, who was, for some reason, didn't make it into the LDF kind of in-group and started his own practice and worked with the National Lawyers Guild and then worked in Danville and in other kind of key sites where movement groups needed lawyers on the ground. And Len Holt said, why can't lawyers listen to what movement organizations want them to do? Why can't, and sort of echoing what JJ said about the earlier panel, taking the lead from organizers, ministers, people on the ground. It's a description of a kind of lawyering that I call a recessive thread, within the public interest lawyering, even within the public interest lawyering literature. That is, most law students don't know that there's this recessive thread. They just think it's ACLU and LDF or nothing, right? That's the way in which to do public interest law. And I mean, I think it's interesting that there's no ACLU lawyer on this panel during the Trump era, right? I mean, they've collected millions and millions of dollars, and I think that's great, and they're doing great work, and they're at the front lines. But I think one thing that you'll see in common in terms of the way we all approach the work is what we're trying to do is we're trying to lawyer to help build power on the ground. Lawyers are not going to build power on the ground. We might be able to, again, deploy tactics that will support movement building and power building on the ground, but a legal win in court is ultimately not going to build the political and economic power that's necessary to fundamentally change the dynamics that were, again, discussed on the first panel, to challenge different kinds of supremacy, white supremacy, patriarchy, as well as, supremacy based on other dimensions of power like ableism. I think I think it's, now, is that work hard? Is that challenging? Absolutely. No harder than, kind of any other, difficult work in this space. But in the sense of, as a teacher, teaching my students to listen, to have a certain kind of a role in relation to movement actors, to their clients, as well as third parties who are important in the lives of our clients, family members, again, as I said, ministers, organizers. I'll say one benefit, it's hard to teach it and to model it in a kind of sort of consistent way. But what I have found in my work over the last 20 years is that organizers consistently push my thinking. They force me to think outside of the box of liberal legalism, right? That is this sort of idea, again, as I said earlier, like, I get a key court decision, a kind of, again, a more traditional ACLU type approach to problems. If I can work my way up to the Supreme Court and get that key decision, that I will have changed things. And organizers say, no, that's not what's going to change things. Liberal legalism is the box that in some way perpetuates exactly the conditions that we're trying to fight. And it entrenches in lots of ways the conditions that we're trying to fight. And so organizers have consistently sort of taught me to, the one thing that I'll just say concretely, I worked with a great organizer in New York City who would always say, don't tell me no. If I want to picket in front of a restaurant, on behalf of the workers, tell me how I can do that. You need to empower me to do the things I want to do. Don't act in that kind of risk-averse, lawyerly way to contain, what movement organizations can do. And again, this is the way corporate lawyers work. They basically, they think outside the box of liberal legalism, right? They're thinking about, how to advance their corporate clients' interests in every way possible, deploying political power and economic power. They don't tell their clients no. That's an ethical crisis within the legal profession, although it's not seen as such. And so what my clients, particularly the political organizers, have said to me is, act more like a corporate lawyer, advance our interests. Don't be so bound by the rules of the game that you can't think about how to get out of that box.
A good organizer friend of mine said you have to be a si se puede lawyer, not a no se puede lawyer, is another way of expressing that point, that you have to figure out how to do the things that need to get done. And you may not, as the lawyer, be the best one to know what those things are. You have to really have a lot of respect. So I just wanted to add, in addition to the points raised about being like who you represent, right? And that being really hard. I think it's really important to say movements don't just show up and say, like, I'm the movement and here's the platform. It often takes years of building with folks, like deep building with folks who have no organization, or who have a dream of an organization, or have an organization that falls apart and builds another organization, or who have an organization about one thing, it turns out it's something else, all that work. And the question about what claims you bring. Again, is it all wage theft? Is it actual structural racial discrimination? Is it labor trafficking that brings a coercion element? Like, how do you actually frame that, and what story and narrative does that develop and enable in a broader sense? There really is a question of what does the legal tactic do? Because we do need those cases that say, people are being treated different in this moment, and that's not fair. Immigrants are being treated different. Muslims are being banned. Black workers can't get jobs because of structural discrimination. But And that's not enough, I think. And there's no time to me than better than in the United States right now to see that even if all the constitutional challenges win, that doesn't stop criminalization, it doesn't stop the raids, it doesn't transform the economy. And so to me, there's an additional question of what, as lawyers, what are the claims that, or the structure of legal work that actually shows the power imbalance. Fundamentally, like, legal cases need to start off challenging the notion of that underscores the courts and civil procedures that everything is fair. And many countries have social justice norms built into their constitutionals and legal framework. Mexico, India, if you come in as a farm worker or a Dalit, the court can say, oh, this is not an even power relationship walking into the court. We have to make that point by every case that gets brought, by temporary restraining orders and motion protective orders and all these things. So what is the maneuvers and how do you show that? And then also, I think particularly on institutional reform and civil rights litigation, I really think we have to be looking at non-reformist reform. We do not want to make these institutions slightly better, although we may, for a particular person in a particular time, want to ameliorate the context. We need to be figuring out the jujitsu of, what is the block you pull out of the Jenga tower that's going to build the movement, that's going to ultimately topple it. And so I think a lot of that is defensive organizers. That has to be the first part, and very few legal institutions are built to do that. And to the law students out there, you have to make this part of your work, whether you're a solo practitioner or working at the ACLU or working at a movement shop, whatever. You're going to have to fight within your institution to make that real, and you have to do a lot of it, and you're not going to know how to do it, but that's okay. You have to want to do it first. But then secondly, we really have to build these new theories and constructions in strategy in the long run. And I think that's, again, where you don't show up, in my experience as a lawyer, and someone tells you how to do that. You have to show up and really, really listen, and then go back, and then come back and listen some more for some time in order to figure that out.
I'm going to jump back in, because I think that one of the challenges that we have, and I'm seeing it, thinking about this more critically recently, is what do you do when the law's actually pretty good? The problem's not the law, the law on the books, or even the law as interpreted, and depending on where you are, the answer may vary. But in Washington, D.C., for example, our wage and hour laws are outstanding. There probably aren't, maybe in California, might be the other example, but even in California and in Washington, D.C., where you have outstanding worker protection laws, we still have very significant violations of those laws. So all of the advocacy that the attorneys have been engaged in, both in terms of enforcing those laws in the courts and those who have been advocating to improve the status of the laws, hasn't, I think, in some ways had the deterrent effect that we would have hoped it would have, which I think is a very kind of glaring mirror of this reality that the law being good actually won't be enough. And so what do we do then? And I think it is causing many lawyers and advocates and scholars to start to think about, what's the next step. I've been writing about a set of cases that are out of actually the Northern District of Illinois in the Chicago area, where there are allegations of discrimination against African-American low-wage workers who apply through temporary staffing agencies. And it's really the most interesting story in some ways to me, because the allegations, and they have there are affidavits from employees from these temporary staffing agencies confirming that, yes, this is what I was told to do, are that they were being instructed, basically, don't send African-American low-wage workers, please send us those hardworking Latino workers. And then they were, therefore, screening out African-American workers. Well, and what's interesting in watching the litigation move forward is that all of us, who are lawyers and, well-versed in Title VII are thinking, it's such a clear, since this is not implicit bias, this is not unclear. It is very clearly a violation of Title VII if the temporary staffing agencies are screening out African-American workers, even if their clients are telling them that that's what they want them to do. I think that the underlying narrative is the reality that it's happening so broadly across the industry that the temporary staffing agencies feel like, well, we have to continue to do this to remain competitive. It's a business necessity at this point to discriminate because everyone's doing it, and if we don't do it, we'll have to shut down. That's an amazing narrative when you think about the reality that this is not a problem of the law. It's very clear without hesitation that that is a violation of Title VII, that no one is going to find that if that's what's happening, that somehow there's some loophole they can get around in terms of being responsible for it. And yes, it seems to be prevalent in the industry. And so what does that mean? How do we begin to address it when the reality is that these things are happening even when the law is very clear on the violations? And that, I think, is in some ways the difference about where we are now and where we would have been 30 or 40 years ago when we were still trying to get the statutes in place that literally made it a violation of the law to engage in discrimination. We now have those. And we now have more statutes in place and stronger laws in place to protect workers, and at the same time, we're still seeing massive violations, which I think does speak to the reality that there are limitations to what the law by itself will ever be able to accomplish, and that it has to be accomplished in conjunction with actual social movements and with worker movements and with people being involved on the ground with changing how our country functions.
Well, I have more questions, but I think we should give people in the audience a chance to ask questions if anyone wants to. Yeah, go ahead. Do you need to go to the microphone, or I don't? Maybe not. This was purely the recording part of it.
I think you raise an essential point. There was, the national prison strike just ended last week, and it was based on organizing around the issue of exploited labor in prisons. I think it's been a really difficult space in which to organize, although I think folks are doing really important work. Are connections being made between, immigrant worker organizing? I think that's starting to happen, partly because you see the same kinds of exploitative things happening in immigration detention centers as well, in terms of, people working for, $1 a day or something to produce products for large corporations. In addition, there are kind of multiple ways in which corporations benefit, as you know, from incarceration, right, that need to be brought to the surface. So the costs of things like making phone calls and doing video calls between detainees and families is an incredibly exploitative practice. And then, the kind of strength of guards, corrections unions is also an incredibly difficult thing to overcome in local economies. I honestly don't think we have an adequate vocabulary to understand how these sort of corporate interests are benefiting from incarceration, both immigrant incarceration as well as mass incarceration, criminal legal incarceration in the United States. I think we're just kind of taking steps towards coming up with a vocabulary. I think we need to think a little bit more about racial capitalism, and I need to learn more about it myself, but Cedric Robinson sort of has this sort of projected a theory of racial capitalism, that is race and capitalism intertwined with each other. So that we see the struggles for racial justice and economic justice not as sort of distinct ones, but in fact as tightly enmeshed ones that are actually operationalized through technologies like incarceration and immigrant detention. But again, I think we're just starting to draw from some of the threads of scholarly work being done in this area, connecting it with what organizers are doing on the ground. For me personally, I feel like I'm on a journey to try to figure out how to make those connections in my own work. I think that could be said more generally as well.
Thank you for putting that on the table. It is very important. And I think this is another area where we really need global thinking and collaboration with movements in other parts of the world, in part because the U.S. corporations that are benefiting are going global, and there are major governance opportunities to, the United Nations right now has a process called the Global Compact on Safe and Orderly Migration. It's supposed to deal with all migration issues. It has over 20 objectives, and the first one is information sharing, which is all about surveillance and border management. Also in there are things about detention and are things about deportations and returns and moving that work from the borders of places like Europe and the United States, several countries out. That's going to be a massive contracting opportunity for the largely U.S. corporations that have built this model that are going to be pushing out. And again, we don't want to just end this here and put it somewhere else. We want to end the practices. So I think there's some opportunities. When I was in St. Louis at the AFL-CIO convention this year, there were a number of global trade unionists there. There was a manifestation by Black Lives Matter and some tensions around it. And the trade unionists from Asia, I couldn't believe that there were police unions. Like, this is not, that they don't have police unions in their country. So there's just, from very basic building blocks, very different starting places. And I think really an ability for cross-learning and cross-strategy building as well.
So I don't know if skepticism's not necessarily the right word, concerns about how we get to this issue, when the reality is that in many ways, well, as a general matter, let's start. It's funny because I'd actually already written this in my notes, that capitalism favors a narrative of political civil rights, not economic civil rights. So our entire economic structure, I mean, that's part of why our narrative of the civil rights movement, that we have as a country very much accepted the idea of talking about that in terms of political rights. Now, there are lots of reasons why that kind of became the face of the movement. If not the reality of the movement, it became the face. And so we still, when we talk about civil rights, and we're only just starting to talk about Martin Luther King and his commitment to economic civil rights, most of us in school probably learned nothing about that. Like, that wasn't something that's probably still not part of the curriculums in the way that it should be when we think about learning about civil rights as in elementary school and high school and in those spaces and even in college. And so what concerns me in some ways of thinking about how do we begin to have this conversation about what's happening for those who are incarcerated is that we can't even have a conversation for those who are brown and Black and poor who aren't caged, because they are viewed in some ways as being the likely to be caged. So once they're caged, they've now proven that in some level, they've now proven that they don't actually, they're the undeserving. So to the extent that there's a narrative, particularly of African-American low-wage workers and the African-American poor as being undeserving. The most undeserving are those who have now proven themselves unworthy and are therefore now caged. So this is not to critique the idea that we should be getting there, but like my fear that we're not there yet because we can't even figure out how to handle the protection of the rights for the folks who are outside of that system. So how do we get to, if we can't handle it in that space, how do we get to the point of handling what's happening for incarcerated individuals?
We have one more person with a question in a few more minutes, but go ahead and ask your question.
Could I just say one more thing?
Yeah,
I'm sorry. And I apologize, but one other thing that I want to bring to the surface is abolitionism. That is, abolitionist activists with regard to the criminal legal system. We see that being picked up in the immigration context as well. And so, I think partly in response to Llezie, sort of the efforts to degrade the capacities of the state to, enforce the law in a way that's disproportionately targeted at people of color, workers of color, that criminalizes, I think could be a common front across communities, and could be a strategy that gets at both the rights of workers who are already incarcerated as well as the rights of workers who are outside, who, again, because of disproportionate state authority targeted at them, are exploitable and exploited. Sorry about that.
Go ahead.
Hi. So my question is, when looking for like what MLK did, it seems that the difference between now and then is just the laws. And as the theologian stated in the first panel, it seems that a lot of it has to do with actually just what we think about people, like our implicit stuff. And like you said, we have good laws, but that state of mind hasn't changed. So my question is, how does the law affect that state of mind to and what extent, and how do you work in conjunction? How do you use the law, but also these social movements? Like, what strategies do you use? Because you might have the law right, but if you can't change people's perception, they might not even want to. So my question, what strategies do you use to kind of change that mindset while also in conjunction with the law?
I mean, I can jump in. I think that's a very good question. We call it culture shifting. And to do so, it's to really shift the narrative, in our case, of domestic workers. And domestic work, because it's seen as women's work, is not valued. And it's also work that has been predominantly done by women of color. And so I think it's embedded in our work and in our members to share their stories and to highlight not only the exploitation that they experience, but to, in doing so, provide dignified stories that connect their value, not so much as connected to having a higher minimum wage, but that their work is worthy by virtue of just being a worker and having human, decency. And so I think that helps in shifting what people's perception is of women's work, of what work is better or more dignified than another work. And that has actually, I think, made it or contributed so that the domestic worker movement, if you will, has been able to make changes. And yes, some of those changes have been, and we're a little behind, is to at least get coverage in existing legal frameworks. But we're also moving toward a direction of defending those existing movements, laws, because there is a movement to undo some of that, in the integrity of the employment relationship by virtue of many companies moving towards misclassifying workers as independent contractors, for example, and our sectors being impacted as many other workers who are classified as contingent workers. So we're doing both things. We're still changing the narrative and the value and how we perceive domestic work, while at the same time not losing sight of the fact that we do need some kind of infrastructure that addresses the inequities that they face.
I mean, one thing I'll say is that this is a battle within subordinated communities, whether to ascribe to a kind of respectability politics to try to appeal to the powerful minority that controls the country, to their sense of whether or not we are worthy or the people that we work with are worthy, or whether to try to challenge the frames that people use to judge worthiness. So in the immigration context, when President Obama said, we're trying to deport felons, not families, that's problematic for the new generation organizers who argue that felons are our families, felons are in our families. Felons are felons because of over-policing and other, kind of sort of structural racism that exists in the country. And so this is a battle as to how to take on the sort of public consciousness, how to shape it, it's easy enough to kind of put out sort of folks who are seen as, again, worthy, and it's much harder to kind of create unity. I think anti-blackness plays a part here as well within immigrant communities, non-African American or African immigrant communities, Caribbean immigrant communities, plays a role as well, in the sense that immigrant communities are often trying to distance themselves from, what is seen as denigrated in the United States, seen it closer to white, and so I think it's a difficult question to grapple with. But I think another way in which lawyers benefit greatly from working with creative organizers who, for example, in litigation will sort of intentionally try to mix up plaintiff classes, both racially, in terms of different kinds of experiences, to try to challenge the narratives and assumptions that people bring to the cases that we're working on.
I also just wanted to add the role of sort of tension and how strategies either create or diffuse tension and what that says about democracy. I wanted to bring it back to what someone on the first panel said, that if we want to address the gaps in democracy, we have to be the people that democracy imagines. I don't think that's exactly right, but it was be the people democracy requires, to quote the first panel. And I think that's in part the question that we were talking about as in terms of legal strategists. A lot of times lawyers reduce tension. A lot of times lawyers channelize tension. A lot of times lawyers want to protect people from tension that the state may place on them. And a lot of times that obscures or tells lies about power that need to be untold. And so just to bring a really interesting and important example from India that's going on right now, there were recently simultaneous police raids in 10 cities that arrested academics, lawyers, trade unionists. And the thing that they had in common was that they were all at the forefront of supporting the Dalit rights movement, and that they had spoken in support of the movement at an important protest. And for that, the police raided and arrested folks, and it's going on now. Now, you could try to make that go away, or you could try to have made it not happen by speaking in a different way, or taking the case to court for permission to speak. But actually, the dialogue that is being created around the willingness of the Indian state, which is another very large so-called democracy, to arrest these fairly elite figures in 9 cities across the country and take their computers and threaten to put them in jail, is creating a very vibrant conversation about the fear of the state when Dalit rights and economic and trade union movements come together, and what the potential that offers to fundamentally transform the state. And I think going back to the question about what's the same or different about Dr. King's time, similarly the U.S. state was terrified of his willingness to bring race and class together. And so I think we see the power of that, and the question of how that gets built in democratic spaces, what tension there is, and who's willing to take risks and who gets to decide that is fundamental.
We're very, okay, I think we're over time. I think we'd better quit, and you can find panelists and ask them further questions if you like. But could you thank this wonderful panel?